afternoon, viewers. This is the newest episode of our podcast, the Slarskey Brief. In this series, we explore hot topics in complex commercial litigation, the practice of law, and risk-based litigation. Today's episode is MSOs, the next law firm frontier. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a boutique commercial litigation firm here in New York. I'm joined today by John Fitzgerald of Citrin Cooperman and Reuben Gottlieb of Gottlieb CPA. Before we begin, I will have an exciting announcement for the viewers, which is we are joining today from our very new office at 825 3rd Avenue. It is literally our first day in this office and a new chapter for the firm, so something we're pretty excited about. Let's start with our guests. Who are you and how do you fit into this world of law firm finance, law firm accounting, and valuation of law firms? John, starting with you.
Thanks, Evan, and congratulations on the move. I wish you the best of luck. My name is John Fitzgerald. I'm a partner at Citrin Cooperman. We are a top 20 accounting firm in the U.S., and I chair our law firm services group. And we work alongside our law firm colleagues in doing tax and accounting work, as well as consulting. And more recently, we've been working very diligently on the MSO practice and providing services for our clients in that regard.
Awesome. And Reuben?
Thanks, Evan. My name is Reuben Gottlieb. I am Managing Director at Gottlieb CPA, and we are a full-service business valuation and forensic accounting firm, typically for disputes, whether commercial or economic damages. We're seeing MSOs now with smaller or mid-sized law firms, which has been pretty exciting, whether it's succession planning or just seeing how they can get liquidity moving forward.
Cool. Reuben, starting with you, my firm has handled disputes and valuation issues concerning law firms. They tend to arise in the context of contingency portfolios and how do you split a contingency fee between two firms and whatnot, particularly in the context of succession or a separation of one partner from the firm. I know you guys have done similar issues as well. What are the issues that you're typically confronting in those situations, and what are the assets that tend to be driving the value of the firm?
Yeah, so the big issue up front is that there's two types of value being discussed. First is personal goodwill, which is why a firm may be generating a lot of money, right? It's one rainmaker bringing in a lot of the cases, trying the cases, and being the face of the firm. And then the second type of value is the enterprise goodwill, which is the value that the firm has as a whole. And so the shift here is, especially with the MSOs, can we get the personal goodwill to become the enterprise goodwill? Can the firm, even if it's generating substantial value, become this great big thing? And so that's really the struggle with a lot of law firm succession planning, separate or inclusive of MSOs, is how do we move forward from a founder-based operation to something more established that can really live on its own. The issue with contingency firm structures is that you really don't know, right? You have no idea if you have a winner or a loser till maybe the very end. And so firms, they put up a lot of money, whether it's associate time or medical experts or financial experts, and it's a lot of effort, both financially and non-financially upfront. And so when it comes to us, we basically talk with management. We talk with who's in charge of the case management very frequently, basically until we finish the report, to figure out how should we value the contingency fees and the contingency cases, because it's going to go on the balance sheet. It's going to influence future income. And really, law firms that have a contingency fee structure, they don't function like a typical law firm where you bill an hour, you get paid for an hour. Contingency firms have this unique structure where the pay off is not determined till the end. And so we talk with management and we have them rate or assess the probability of success moving forward. And so then we record that on the balance sheet, and that influences the value in two ways, because business valuation or law firm valuation is not just one path. We value a law firm in a multitude of ways, and that's how we get to the final number.
John, I know you've been doing a ton of work specifically in the world of law firm MSOs. What is an MSO, particularly in the context of a law firm?
Yeah, so obviously law firms are a unique enterprise. In New York, law firms can only be owned by lawyers, licensed lawyers. And in order to get investments from third-party providers, a structure was devised to allow firms to get outside money through an MSO, a master service organization that basically sits alongside the law firm, which allows money to come in through a third party that's not an attorney. And what that service provider does is provides non-legal services to the law firm. It doesn't share revenue because that would be an ethics violation. And it just sits there to provide IT support, financial support, clerical support, whatever support they could bring for a fee. So the law firm is just practicing law. So it became a vehicle that allows the law firm partners to get third-party money in. And that money could be used for variable sources. It could be used for technology. It could be used for expansion. It could be used to pay out certain partners. It could be used for various amount of money. In the past, law firms didn't have an ability to capitalize on their goodwill. As Reuben stated, the value of the firm. And what this is allowing law firms to do is to capitalize on that value, but also providing the money to expand. Just like private equity has come into various other industries, including the medical field, veterinarian field, the accounting field. It thinks law firms is another good investment strategy. So we're seeing a lot more activity in that space. And I think over time, what we're going to see is it's going to be an opportunity for firms to expand their footprint and combine more quickly, because one of the barriers to law firm combinations is the cost. And I think this is what you're going to see is going to be a period of time where you're going to see more consolidation.
Yeah, I have a question for both of you. I can imagine there being both good reason and bad reason for taking on an MSO structure or private equity. Based on what you guys are hearing, what are we trying to solve? Are these liquidity crunches or a genuine need for outside capital that otherwise didn't exist? Or is it succession planning? Is this greedy private equity? What are the reasons you guys are hearing for MSO capital?
Well, I think from what I'm hearing from our clients, clients are concerned if they don't consider this, are they going to lose their competitive advantage? Where it's going to be harder for them to retain talent, harder for them to do inorganic combinations because they don't have access to private equity. And if they don't become what you would call a platform firm, are they just in a position where in 3, 4, 5 years, they're going to have to merge into another firm because of their inability to potentially get talent and their inability to grow? So their concern is really more from a strategic standpoint, what this means. And with the cost of technology, with the AI evolution that's ongoing, there's a concern that maybe firms will not have the ability to invest as much as they need to stay competitive with a firm that has outside money or finance money that can come in and kind of fuel that validation, can fuel that technology growth. So they're kind of looking at this from a standpoint of where are we in 5, 6, 7 years if we don't do this? And I think they're looking at it from a pragmatic standpoint. I don't think they're looking at just as a money grab. Hey, we can get some money out of this. They're saying, hey, what's the best thing for our firm in order to be in the right position for the future? That's what most responsible managing partners are thinking about.
Reuben, are you seeing the same thing?
Yeah, so I think John is speaking to my first thought, which is that the synergy of having someone take over the non-legal aspect of running a firm can be just tremendous, right? What is the number one thing that you complain about, Evan, at work? That the client work becomes the back seat because you're doing all this other non-legal work. And so when you have an MSO, it kind of takes the pressure off of the lead partners or the lead team members to practice law. If you wanted to go be a businessman or a businesswoman, you probably wouldn't have gone to law school. You probably would have done literally anything else. The other thing that we're seeing is, and maybe this is with law firms that are doing revenues between 10 and 20 or 30 million, is that there's no succession planning. I work in a family business. I'm the heir apparent, right? There's someone to take over and pay out the name on the front door. Where in other firms, if there is no heir apparent, the firms they're in a situation where they need to figure out what to do next. And so having an MSO allows the firm to take a leap forward, and they do get liquidity. It may be a money grab. It may also be a real opportunity for the firm to have a legacy beyond just the founders.
Look, there are great reasons to pursue an MSO or raise outside capital through debt, through law firm financing, whatever the case may be. From your guys' perspectives, are there any situations you're looking at and you're like, that's an area where you don't really need the MSO, or maybe this is just not a situation that's a fit for the solution?
Well, I think there's execution risk anytime you do a transaction, right? You're going to spend a lot of money. What happens if it doesn't sell, right? If you want to retain full control over everything, doing an MSO is not going to allow you to do that.
Right.
No short-term exit pressure. You can make decisions that you think are right for the long-term growth of your business without being worried about an outside partner. And the other thing is you're preserving your firm culture, right? If you were built a certain way,
Right.
and you think that's the right way to work and you don't believe in changing that, then maybe the MSO may not be the right thing for you, because things will change, right? And also there's a regulatory issue that we really haven't spoken about, because I'm certainly not qualified to speak on it, but there's concerns if this is going to be challenged in the future from a regulatory perspective. And I think if you spoke to ethics counsel, I don't think you're going to get an answer that says 100% certainty that there's not going to be an issue here. So I think there's concern as to, hey, if we do this and spend all this money and uproot our firm and make all these changes, and a year and a half, 2 years from now, we get a letter from some bar or some ethics area that says, hey, you're violating Rule 5.4, you have an issue. I mean, that's certainly a concern for some firms. Other people believe that it's sound and there's no issues, but time will tell, right? With everything else. So I think there's certainly strong reasons to remain independent. I think it's just your view of the future. And if you feel like you have a strong firm that has a lot of good up and coming talent that can grow, and you can generate revenue on your own, and people want to invest, the partners have to want to invest their capital back into the firm. If you want to take every dollar out, it's going to be very difficult to remain competitive with firms that are spending money on technology at a faster rate than you are. So I think you have to really think about, are you willing to spend a percentage of your revenue on technology that you haven't in the past?
Yeah. I mean, look, there are firms that are not, they shouldn't be scaling. They're not the type of firm that can scale all too much because it's a boutique, because they do one thing in tax or a funky part of transactional law or a specific type of litigation. And there's nothing wrong with that, right?
And they would be staunchly independent forever, right? If they have a niche that they can stand on. But that's going to be a decision they're going to have to come to on their own as this evolves.
I think there's also a component of fear, right? We see all this money going into AI, and smaller shops look at themselves and say, well, how do we move forward? How do we make the leap? And so if you don't get some money, what are you going to do? The risk, obviously, is that the MSO agreements are going to bleed more money out of the firm than the synergies that they bring in. And so I imagine that what we're going to see in the next 5 or 10 years are more MSOs, but perhaps for us, people who are in the litigation business, fights over these agreements. And maybe the expectation that the firms didn't do the revenues that they thought they were going to do. I know with the smaller businesses, there's a key person issue in all the firms, right? You have someone who's in their 60s, even in their 70s, and they're the cheese. Everyone comes to the table for this one person or two people. And so if they're phasing out their career and there's no next generation, you have a real issue. Now, I think John speaks to this aspiration that they're going to invest into the firm in the next level of talent. And that could be really exciting, because sometimes people just need the right resources to grow and take the firm to the next level. I imagine it's a little bit of both, though. There's that generation that wants to kind of sunset, and then there's this opportunity that the firm could be something special, or more special than it currently is.
You hit on an interesting point, which are, these are lawyers at the end of the day, and then they're rubbing up on an evolving model Rule 5.4, which isn't entirely clear what you could do in any state. What happens if you're in a state that still has 5.4? What happens if you're in a state that no longer has it? And you have lawyers across jurisdictions, people who are concerned about their own legal status as a lawyer, and always have the weapon of using that law license against whoever that investor is. We've certainly seen it in the law firm finance space, where the occasional lawyer took in litigation finance and then just disagrees on the tail end with what the funder's rights purportedly are. I guess it's a particularly interesting equation in the context of lawyers versus accountants or doctors or dentists, whatever the case may be.
I think what it reminds me it reminds me of earnout disputes. And so,
Yeah.
basically people, they walk into the transaction thinking that they're going to do X, Y, and Z. And then even the calculus of the revenues and the calculus of the fees become up for dispute. I think it's an opportunity for us to make sure that the world knows that we can do these calculations based upon the agreements and help people navigate that. But it reminds me very much of an earnout dispute and an earnout type of contract.
John, the greatest analog I could kind of think of to somehow predict whether this whole thing is for real, whether it's going to work out, is accounting firms. The upper middle market, the large accounting firm have gone through a tremendous amount of M&A. Is this analogous to accounting firms?
I think so. I think so. There's one strong difference. Law firms don't have non-competes that accounting firms do. And I think one thing that the MSO does, it does maybe give the law firms a little bit of an ability to retain people longer by giving out equity in that MSO to their partners. So it's strange to think that someone's going to invest in a company that doesn't have non-competes, but that's the business. But on the other side, it could give opportunities for the law firms to keep their attorneys by having them with a rollover equity that they would want to wait for a vesting period or wait for a turn where they could capitalize on that investment, which could prove to be valuable and something that law firms never had in the past, the ability to get a multiple of the value of the firm. So many people have been involved with working with firms for 35, 40 years. They've seen the value of the firms increase tremendously. And then when they retire, they really don't get to share in that increased valuation. And that's one thing that this would potentially fix. So I do think there's some strong correlations to the accounting industry, which is very simple. In the accounting industry, people were given an unfunded retirement provision that they were going to get over a period of time, which is really like an IOU. And so it is very similar. I think the non-competes make it a little harder to definitely value relationships, but it appears that people have gotten over that fear. And we're seeing strong valuations coming out for firms at EBITDA numbers that are very similar to what the accounting firms are trading at.
How about when you fold conflicts into the fold here? Is that meaningfully different from accounting firms, or do you view it as not terribly far off?
I think the conflicts are going to be more of an issue for law firms than they were for accounting firms. There's a higher standard, I think, there, and it's going to be something that has to be managed. But I don't think it's going to prohibit the transaction. I think if people want them to happen, they will find ways to make them happen.
So, John, what is your take on the differences between the structures of accounting firms and law firms? Because accounting firms, they have a tax practice or an audit practice where it's a lot of recurring work, where law firms, especially personal injury law firms, it could be one-off cases, which is, they're very different.
Yeah, I think that's a great question, Reuben. A traditional accounting firm has a lot of recurring compliance work from year to year that you can count on, regardless of the economy. People have to file their tax returns. They need their test work done. So you have that recurring revenue. I think law firms, the underwriters are probably going to look at it over maybe a longer period of time. They want to get an understanding of the growth of the firm over a period of time, maybe do a little bit more due diligence. But I think overall, the pricing is going to be very similar. They're going to look at recurring revenue. And I think contingency companies are a little bit different. They're going to want to understand the cases and the history that the firm has had on their rates of conversion. But I think just like any industry, there's a value to that, and the underwriters will determine that. And we're seeing that contingency firms have a little bit of a less EBITDA multiple than we're seeing in full service firms. And I assume that goes directly to your point that because they're harder to underwrite, they're harder to value. As a valuation expert, I'm sure you go through that all the time when you're trying to figure out a valuation for a contingency-based practice versus a commercial practice. Obviously, there's probably some discounts involved in contingency firms because of some of the lack of predictability, I would say. So I think it'll come out in the multiple. And I think the underwriters and the investment firms, the private equity companies will understand what they're bidding on and they'll be comfortable moving forward in that range because they're going to look at a holistic history of the law firm over a period of time. And I think they'll be more concerned with some of the ages of some of the partners than they are maybe with some of the up and down fluxes in the revenue because the partners are going to be the ones that really drive the revenue growth.
Recurrent revenue is kind of it's an interesting beast, right? In the world of accounting, it'd be, well, we're doing tax returns every year. But in the context of a law firm, it can be we're stomping out the same type of case however many times every year, or we're a big firm and we're representing XYZ private equity fund again and again and again on whatever transactions they're doing or issuances or whatnot. Well, guys, my last question to each of you is, what are you predicting, right? What are you hoping to work on in the MSO context or outside of it in the next few years? And what are you keeping your eye on in this area?
I'll go first then. My prediction would be that you're going to see a consolidation of mid-size law firms.
Mm-hmm.
There's an enormous amount of law firms. I think Reuben stated it really well earlier about the next generation. If they have someone there to take over. So there's a tremendous amount of law firm owners out there that don't have a succession plan. And I think this lends itself to that. I think an opportunity to consolidate a fragmented market is an investment that people are interested in doing. It's been something that's been successful historically over the years. And I think those mid-sized law firms are primed for this. I think the bigger law firms like that top 25 or the top 50, I think it's a different world for them. I think you may see MSOs there, but maybe for more financing as opposed to maybe private equity. I could be wrong, but I really think the opportunity is going to be in the middle market where they're going to be ripe for consolidation and you can really increase the value by synergies that occur as you combine some of those mid-sized firms.
Yeah, I think that's spot on. We don't know where or who the winner is in the AI right now. There's Harvey's, there's Legora, there's all these other firms. We don't really know what the price of AI is yet. You read all the time that AI is cheap right now. And so we're all getting cheap AI. I mean, it's all subsidizing our firms as we're using them and navigating them. And what's going to happen is that the cost of being the next generation firm, and I'm not talking about the next practitioner, I'm talking about the next frontier of lawyering and accounting, it's going to be more expensive. And so there's going to be a greater need for money. And I think we're going to see that firms are going to have to find a way to access capital to make that leap. I also think that there's going to be a lot of disputes over the calculations of the fee. And I think that just because I litigated earn-out disputes myself before I transitioned to business valuation full-time, I think that people are going to want to navigate that in a way that may not be so litigious.
My own perspective on this is, we talk a lot about law firms. Why might the issuers or the sell side be interested in MSOs or litigation finance or what have you? I guess there's an interesting question from the buy side too. Private equity likes to cut big checks and make multiples and plop their own people and their technology and do what they do to make them more efficient and more profitable and bigger, right? And I wonder if the law profession will satisfy them. Are some of these law firms ripe for scaling? Are they ripe for some of these synergies? The legal profession is replete with finicky folks who are able to do really great things at small and mid-sized firms and boutiques and even big firms. But when you have private equity involved, all types of fun things can happen. So I guess one thing I'll be looking at is from the perspective of private equity, do these types of investments pan out the way that the funders hope, or is this a blip that is not something that will have staying power?
I think that's a great point because when you make that decision to do an MSO and take that investment money, you're changing the way you're practicing law, right?
Yeah.
Now you need to start thinking about an integration team, because you're going to be going out there and acquiring firms that you've probably never done at the scale you're going to do it. So how are you going to do that? Who's going to lead that charge? How are you going to make sure it works? How are you going to onboard it to make sure that the synergies happen and keep everybody happy and maintain the clients, right? You're going to need to have a much more fulsome and robust accounting department and people that deal with GAAP accounting and understanding what that reporting is, and having quarterly or however often board meetings and things, a level of financial rigor that probably you never had before. You'd say, oh, don't worry about it. We have enough money for that, or don't make that check today, or whatever you need to. We're not making that distribution right now. It's going to be a different model on how you think through all those things. So I think firms really need to think and understand how they're going to change with this model and have to professionalize some of the things they're doing currently. And to your point, Evan, it needs to be really thought out, because you made a point earlier about practicing law. Well, if you're the CEO of a law firm that just took MSO and PV, now you became the CEO of an entity that you need to now operate a business differently than you had before. And you have to make sure you're up for that challenge.
Well, John, Reuben, thank you guys so much for joining today. It's been an absolute pleasure having you guys on. And viewers, thank you for checking in, and see you all soon.